Hey, test, test. All right. Good afternoon, everyone, and thank you for rejoining after a quick coffee break. I do not believe introductions are in order. So, Professor Jan Paulsen will be speaking to us about third-party funding as it is relevant to this year's problem, and maybe as well just a bit on the IBA taking on evidence. But the focus, I believe, will be on the third-party funding. So I leave the floor to you, Professor.
All right. I hope this will be an interactive session. And I thought I might start out by saying a few words about the Pre-Moot, which I consider to be an amazing sociological phenomenon, which has created, which has made a huge difference in the practice of international arbitration. Now, since arbitration is the way in which international disputes are typically resolved, or very frequently resolved, that sort of might surprise you. It might amaze you that the fact that a large number, but still it's not 100,000 people showing up in Vienna, that could have the impact it has had on the world. But let me try to convince you of that. In my student years, I did not listen to 5 minutes about talking about arbitration. I went to law school in the United States, France, and in neither of those places was arbitration a subject for discussion. I began to practice in 1975, and as it happened in Paris, and as it happened, one of the first things that happened, as I still from wondering what in the world I would be doing when I was practicing law, was that there was a little arbitration. Now, let me suggest to you how the world was then. I had studied, as I said, in the United States, and I was a member of an American bar. But in France, not being a French citizen then, I am now, I didn't have the right to be a lawyer.
Sorry, just got a message from recording me to mic to be closer.
Okay.
Yeah.
I'm surprised that I'm not, oh, it's for recording purposes. All right. That's what it is. Otherwise, I would have thought I'm only trying to reach the group here. So the landscape of practicing international law was hugely different and very limiting in lots of ways. So I could not practice because of my nationality as a lawyer. I could be called legal advisor and work in a firm where you could only have legal advisors, but none of us could go to court. We could participate in arbitrations, but arbitration was not very common then, as you might imagine since I just told you that it wasn't taught in the law schools. So universities tend to respond to what the need is. And that's you study the subjects which are relevant in a particular field, and arbitration just was something sort of weird that happened once in a while, and it wasn't quite. Is it really law? Is it really? I mean, it's when do you go to court? At some point, you must go to court, right, to get that corrected. And if you're unhappy with what happened, there was really very limited understanding of the most basic questions about it. Also, back then, let me give you an example. You think of the United Kingdom, you think of England, I'm sure, as a leading center for international arbitration. It wasn't. It was a backwaters. Until 1979, arbitration was not final in England. As simple as that. A disappointed party in the result of an arbitration in England could state a case to the court. That was the expression, state a case. So if they indicate that there was something wrong in the way law was applied, well, only courts can tell you what the correct application of the law is. So how can you imagine that somebody who is not a lawyer would be able to, who is not acting as a lawyer on the day, as called an arbitrator, could make a statement about the law that would be binding? You could always go to the court and get that corrected. In the legislature of England at the time, somebody stood up and said, "Do you realize? Isn't it amazing how people do things as they speak?" Somebody stood up in the parliament and said, "Do all my colleagues in this legislature realize that we are losing 300 million pounds of fees by people refusing to come and arbitrate in London?" That's a true statement, and that you can see reported because all those remarks in Parliament are recorded and you can read it. How would he know that number? I cannot imagine how you can think it must be a lot, and I'm sure that's true, but I don't see how you could possibly even guess what it was. But the truth was that arbitration in England international arbitration was rejected from people outside England. That's not a place to go because if you've chosen arbitration because it's neutral, you want to go and have the arbitration. It is final and end up in a national court, obviously. So the English straightened that out, and not until 1979. You still had the business of, well, who can really practice and so forth. Germany, in a way, was worse than France because the bars, I mean the legal bars in Germany, were different province by province. And you would qualify as a lawyer in one province and then couldn't go into the next province unless you got some special permission. It was very restricted. That also was very complicated to live with and was not good for the economy of Germany and so forth. So that was changed in due course. Now, why am I telling you all this? The participation of young lawyers in international arbitration today is night and day different from the way it was not so very long ago. And it seems absolutely extraordinary. International arbitration was not thought of in the terms of those words. It was thought of, I have a client who has a clause in a contract which says an arbitration in France. So that's a foreign arbitration. I'm an American. I sit in New York. When I think of arbitration in New York, maybe not even in California. So I have a client who has signed a contract, maybe even in French, and calling for arbitration in France. I don't do that. That's a foreign arbitration. I am an American lawyer. I'm not a foreign lawyer. And then, practicing in Paris at that time became quite a luxury for a number of lawyers because we would get calls from New York of the leading law firms in New York who would have an international arbitration. And they would think of it as a foreign arbitration. So they would say, who do we call up in Paris who can do this case? They couldn't imagine that they could do the case. The largest law firms in New York. What a luxury for those of us who were in Paris. And we got a good start that way. So as time went on, the people who practice in the field become more cosmopolitan and people care less about nationality. So, for example, if I carry on the illustration of France, which I know the best, when it opened itself up, the French said, anybody can become an avocat if you qualify for it. And anybody can participate in an arbitration, and you cannot appeal on the merits from arbitration. That made all sorts of law firms in the world think we need to be in Paris because it's the center of arbitration and it's a large city and we need to be in Paris. And let's set up, and they've also said that foreign lawyers can come up and set up law firms, not legal advisor firms, avocat, cabinet d'avocat. What a great bonanza for international firm. What a great thing for all the big firms in New York that can come in Paris. Now, let me just tell you something, that's the wrong picture. It is true that in Paris today, you have, I think all of the major law firms in New York have an office in Paris. Who work in these American offices in Paris? Count them. Okay, so back when I started, the American firm in Paris would be called legal advisors, even though back in New York they would have full rights of lawyers, and they would just sort of be hand-holding clients and try to explain to them what the funny French do in the courts and so forth. But they were all Americans. Once the road was free for non-French law firms to practice French law, guess who started to fill up the foreign law firms? The foreign law firms, French lawyers, and French lawyers have a great advantage when they're practicing in their own country, obviously. So I tell you today, go look at the populations of the major German, English, American law firms in Paris and ask yourself, what countries do these people come from? Overwhelming majority of them are French because they are living in France, and from time to time they go to court and they're bilingual. And that is a tremendous sociological evolution. And the Vis-Moot, I will tell you, has a large part in that. And you will discover that as you go through your adventure this year. Its significance is astonishing because it doesn't take all that many people. What it tells is that the message goes, and all of a sudden it's around the world. That's the remarkable thing. And you will meet people from different countries who think about legal problems the way you do because they've been exposed to the same problems. And they are reading documents, as the ones you are doing here, that have been written with the influence of international organizations which think of international model laws, model forms of arbitration rules, and so forth, which combine to make things a lot easier for everybody, no matter where you come from. It is a tremendous change in the way law is practiced around the world. And as young people meet so relatively many, see, it isn't really all that many, it's a drop in the ocean. Well, not really. I mean, there aren't that many people who practice internationally. And so those who have the experience of Vienna go back to their countries, from Korea to Venezuela to Malta, all over the place, and they become familiar with the approach and with the language. It opens doors in a way that you absolutely cannot believe. And the fact that you are so young and impressionable makes it even more likely. I sometimes wonder, I would like to know how many people in the legal profession got married and met in Vienna. I would really like to know what the number was. I'm not going to get into that subject. You can just see what I mean. It's just a tremendous opportunity to see people and realize they're like me. They have my ambitions. They have my interest. They want to do this kind of thing. Legal problems all over the world fundamentally are alike. It's complicated stuff, and the laymen don't know how to do it, and they need legal assistance, and that's what we're doing. And if we learn how to do law properly, wherever we come from, doesn't make any difference. It's tremendously liberating. So that's my little vignette of what life was like 50 years ago and how it's changed in a way which I think is absolutely revolutionary. And I'm lucky to have seen it, and you're lucky to be in it. So I wish you the best of luck, and I will predict that when you get to Vienna, you will remember what I said now, and you will write me and tell me I was right.
Thank you very much, Jan, for that.
Let's move on.
Yes, to move on to third-party funding, because you want to keep it interactive, we have both Sarah from Royal University for Women and both Sarah and another Sarah from Al Faisal University, if I'm not mistaken. So they're going to interject with a few minutes from their time, and then we will give the floor back to you to continue.
Thank you so much, Professor. So once again, my name is Salam Shari from Al Faisal University. So to give you an overview of claimant's stance in regards to this issue, claimant believes that all disclosure requirements under the SIAC rules have been met. Firstly, SIAC 2016 rules don't have any disclosure requirements in relation to third-party funding agreements. The only thing in relation to it is the 2017 SIAC practice note that stipulates that disclosure of the identity of the third-party funder is required in cases of conflict of interest. Here in our present case, there is no conflict of interest potentially with any of the members of the tribunal, therefore not necessitating any disclosure under 2016. And then when it comes to the 2025 rules, even if they apply, which claimant does not want to apply, the disclosure requirements are threefold. Firstly, the existence, the identity, and then the contact details. Here, claimant believes that it has met these obligations completely. One of the reasons that we don't want to disclose our third-party funding agreement is we believe it will unduly restrict our ability to have an efficient claim, as it gives the respondent insights on our strategy, arbitration strategy, as well as we believe that there's no basis for security for cost measure, as we have an adverse cost insurance. And lastly, that there's a confidentiality clause between us and our third-party funder, and we don't believe that it meets the standard in the IBA rules on taking up evidence for materiality and relevance to the proceedings.
Start that sentence over. You don't?
We don't believe that since there's a confidentiality clause between claimant and the third-party funder, we don't believe that the disclosure meets the standard in the IBA rules for relevance and materiality to the proceedings.
You criticize the wording of the disclosure?
We believe that disclosure is not required for the third-party funding
That's
agreement.
different. Okay.
Yeah.
Okay. Fine. That's what fine.
Hello, my name is Sarah Sharaf Ali from the Royal University for Women, and I'll be giving a brief overview on the respondent's position. First, that the tribunal has the power to order disclosure of the funding agreement. First, we submit that under the 2025 rules, according to Article 38(4) of the SIAC rules, the tribunal, after hearing the parties, has the power to order the disclosure regarding the third-party funding agreements as it sees fit, including the funder's interest in the outcome and any commitment to cover adverse costs. Therefore, under the 2025 rules, the tribunal has the power to order the disclosure. And assuming but not conceding that the 2016 rules apply, we submit that the tribunal still has the power to order the disclosure. This is under Rule 27F of the 2016 SIAC rules, which confers a document production power to the tribunal. And under the 2017 practice note, the tribunal can order the disclosure of the details of the external funder's interest in the outcome of the proceedings. And we submit that the tribunal should order the disclosure, as the disclosure is relevant for a security for cost application. Given a claimant's precarious financial situation, it may be unable to satisfy a potential adverse cost award, even through it after the insurance that they have obtained from Litshore. Disclosure is also necessary for a respondent to make appropriate provisions for claimant's further damage claim, which claimant has reserved its right to claim its funding costs. And lastly, disclosure would reveal 8AG funding's influence over the proceedings, and respondent must know who effectively controls the proceedings.
All right. So now that we've gotten a fair share of both claimants and respondents' views on third-party funding, we go back to you, Professor, to share your thoughts.
Well, I will just ask questions. You might, and that's all I'll do for even when I come back later in the week. I'll just ask questions. If let's say that there is no third-party funder involved. So we'll just start with the ABC of this. Just have two parties. And the claimant is unhappy, has been losing money or losing something. It's not happy, has been losing money. That might mean that it's sort of lacking funds, and wants to put on a good, strong case, and that takes some money, but it doesn't know anything about third-party funding. It's never heard about them. So it's sort of in trouble, and it has to beg from friends and find some way to have some money. And when the case is over, if it loses, there's nothing left. Should that be allowed? You can bring a case. Who says that you have to have money to bring a case? We're not talking about any third-party funder. Why isn't a party that has been ruined by its adversary and is now bringing a case, which we assume a priori it has something to say. It has a claim. It's been really badly treated by the other party, to the point that it really has very little money left, and it scrounges up for some money and spends it in the arbitration and loses. Should that be allowed? So my point is, what's the difference between that and having a third-party funder? Why should the winning defendant be in a better position just because the party that attacked it had a third-party funder?
I think if you have another question, maybe we can share with the audience. If you could rephrase the question.
Rephrase the question. Okay. Case A is, in the situation, we have a party which considers that it's been badly treated, and one result of being badly treated is that it's sort of spent a lot of money on this project and doesn't have very much money left. Okay, that's common in the two situations. In the first situation, nobody's ever heard of third-party funding. If the claimant loses, as they said in the country which I grew up, which was in West Africa, you can't undress a naked man. So why should the respondent, which has the fortune of defending it successfully, why should the respondent be in a better position just because the claimant, which lost ultimately, did have access to a funder? What's the principle? We're all you should all have thought about the principle of this.
Which is probably the principle of access to justice and to have a fair and equal standing before the
Yes, if you like, but
proceedings. Yeah.
more fundamentally, why should there be a difference between the two cases?
Mhm.
You don't have to have a third-party funder. And you might feel better because maybe you will have more. If you have more funds, you can make a stronger case. But
Any comments or thoughts?
yes,
Please introduce yourself and share your thoughts.
Hello, Professor. This is Wenjuan Ma from Hamad bin Khalifa University from Qatar. And I understand your question is about like everyone, like every companies have the rights to access to the justice if they lost or something. But the reality is, if it comes to arbitration, it costs a lot to start to apply for to apply the applications through the institution around the world.
I didn't understand.
So
The last-
because you mean they can still access to the justice without the third party funding. But the issue is if a company is like nearly have no profit this year, they don't have money to invest into this kind of litigation or arbitration in the arbitration center, how can they access to this kind of justice without the money they need?
Well, that's a question you pose, and maybe it's available or if it's not available. I'm taking a position that a claimant, nobody's heard of third-party funding. So this is an arbitration some time ago, or maybe in some place where just nobody's thought about it. And you have a claimant, and the claimant considers that it has been very badly treated by the other party. And that's why, one of the reasons it is in such a poor position. And it can bring a case by looking all over the place, finding a dollar here and some little money here and getting a friend to contribute something, but it's not as strong a case as it could if it had help, and it believes it has been aggrieved. Okay, it loses, and the respondent says, "Wait a second, you caused me damage. I had to defend that case, which I won, and you were wrong, and you started that case. You pay me money." Well, there is no money. Why should the respondent be in a better position if there has been a third-party funder?
I mean, there is another principle I can think about is like for example, the arbitration center or the court, if they deal with a lot of cases simultaneously, it's a waste of the justice resources to make other companies to access to the justice at the same time. So to prevent this kind of situations happens, it's not like randomly the claimant can start a case against the respondent, you taking use of the other money that is not in, like if the situation is not in favor of the claimant, then it's like on purpose to start a useless case. And we should avoid this so that maybe you think the respondent should be in a better position when there is a third-party funding in one of the arbitration cases. Am I correct?
I think we have another some comment as well over here.
Hello, I'm Aya Nabil from Nahrain University of Iraq. Now, I may refer that the respondent need the disclosure of the third-party funding to the purpose of the disclosure itself, which connected.
Repeat, I didn't understand the last two words.
Okay. The connection between the third-party funding disclosure and the advantage to the respondents is that the purpose of the disclosure itself. It gives the confidentiality and fairness. In addition, that the parties, both parties and the tribunal in the arbitration proceedings, aware of any parties could have any interest in the outcome of the arbitration proceedings.
Well, okay, let's consider something. I'm looking now at SEAC practice note on this subject, which I'm sure you can look at. So you see that SEAC has a very short 2 pages document on administered cases and the treatment of external funding. So when you look at the very last comments of this, the very last section talks about what happens at the end, costs. So that's where we are now, like the consequences of the case. And the cost we think of go to the successful party. And I've been focusing a respondent that has won. Okay, so what do we find here? If you see, it's paragraph 10, it's very simple. The tribunal may take into account the existence of any external funder in apportioning the cost of arbitration. So what do you suppose that means? It seems logically just understanding those words is if there has been an external funder which has enabled a party to bring a case which it then lost. Isn't the message relatively clear? Then the tribunal can take into account the fact that the losing party used an external funder. And what does it mean, take into account? It's going to be more costly for that respondent. And I'm asking, this is my question, why? Because we're in favor of defendants? Like, we wake up every morning and we... Yes?
Equal treatment of the parties and the right to fully present your case. Fundamental procedural principles.
Yes, so explain that. That's an abstraction, not concretely.
They will take that into account in allocating the costs between the parties, because the tribunal has the power to allocate costs of arbitration, so they can allocate more cost to one party over the other.
Well, that's a power that it has, but here it says that this is a little practice note about external funding and the consequences of external funding. And it says, if there has been external funding, the tribunal may take that into account. That presupposes that what happens in the case of the involvement of an external funder, that's going to make it worse for the claimant. Or are you punishing the external funder, which is not a party?
Not necessarily. They would take it into account, but that doesn't mean that they will allocate more costs to claimant or raise the bar for claimant in terms of costs. Because we go back to the idea of access to justice. Why would claimant bring in the claim? I mean, since the parties have an arbitration agreement, claimant cannot really go to court. So they will have to go to arbitration unless they could prove to court that they have an issue of access to justice because of lack of funds. This is not a very conclusive matter in terms of courts, because when the other party would prove that the existence of an arbitration agreement, the court will send them back to arbitration, and we will be in a loop. Claimant cannot present its case, or cannot raise its claim. So that's why they would resort to a third-party funder to access to justice, or to be able to present their case or bring in their claim.
Is it based on a policy reason to try and reduce people reverting to third-party funding for spurious cases or capricious cases? Are they reserving the right there to punish people who have brought a spurious action purely through third-party funding?
Well, it's a valid observation. I just don't want to give too much away of what I might say on a later occasion. But I think that's taking the discussion to a more sophisticated level than saying we don't feel like encouraging claimants. That really doesn't sound right. Why should somebody we don't assume that the claimant doesn't have a good case. So the claimant brings a case, and sometimes they don't have a good case. And perhaps the facts are very good, but the law isn't very bad. And you don't blame them for bringing a case. They couldn't have walked away from it. And if they don't have any money to pay costs, well, nobody said you can't bring it because you don't have money. Why should that be different if you have a third-party funder? And what you're bringing into the discussion, which strikes me as relevant, I'll just say that, is that there are third-party funders and there are third-party funders. And some of them might be rather adventurous. Some of them have a huge portfolio and they think, I just need to win one or two. If they're big enough, and if I see that things are going very well in the arbitration, I will sort of pump more into it and I will really focus on that case. And that sort of makes the situation questionable in a way that isn't true if you're just, unless you have difference of behavior of the external funder. So I think these might be an institution, like many of us are looking at external funding as something relatively new in the last decade, 20 years. It's a fairly new thing, and many people have not seen it. I am not, I've been an arbitrator in hundreds of cases, and I cannot remember having ever being involved where the question of a third-party funder came up. There undoubtedly have been some cases where they were there, but maybe the outcome was such that it wouldn't have changed anything. So I just haven't seen it. But now it's becoming larger, and maybe there are third external funders who like to take long shots and have very, very sophisticated way of working it out, or else you have new entrants who are a little bit crazy and, they haven't been around very much and they don't know what they're doing and they spend a whole lot of money. And that shouldn't, yes, exactly. Any other comments?
Any other comments, or maybe if you have another observation or question to also engage our minds and grind our gears a bit to think deeper into the subject. Oh, we have one more.
I'm Zaki and I'm from Al Nahrain team. I think that respondent would be in a better position to not even disclose the third party. If the third party is disclosed and a factor or not was in a conflict of interest, was unbiased, and it would affect the arbitral tribunal's decision in favor of the respondent, and we say that claimant is broke right now, how would the respondent get the money from the claimant, to put it simply? If the third party funder is, let's say, excommunicado, out of the way, and there is only respondent and claimant, the final decision of the tribunal would be money. If it was fees, if it was anything else, premiums, how would the respondent get his money?
What if there were any way of knowing of all the populations of parties in cases where I'm going to ask a question here, so don't take the mic away. If we knew about the populations of all parties in cases where there are third-party funders, okay, what percentage of claimants and what percentage of respondents have had access to a third-party funder, would you think? How often is it the claimant and how often is it the respondent?
I think the claimant has definitely a higher percentage of having a third-party funder because he's the one that's bringing up the case. So if he doesn't have money, he would, of course, have a third-party funder in his pocket to support him. and financing.
And you would think it would be sort of probably a bit more on the claimant side, or like almost all?
If the third-party funder of claimant knows that the respondent has a competition in the market, he would reach out to this competition and maybe get him as a third-party funder.
No, back again, a simple question. What would you imagine would be the split? How many of all the people who get third-party funder, what percentage are claimants, what percentage are respondents?
70-30.
Okay. Anybody have another idea? I don't think anybody knows. I don't see how you could know. People don't tell these.
It's like, so maybe to rephrase, like, who do you think would be more likely to approach a third-party funder, a claimant or a respondent? Maybe by show of hands, who thinks claimant is more likely? Okay, who thinks respondent is more likely? Okay. Interesting.
Would any of you who said respondent
Care to share why?
yeah, imagine a scenario. What sort of situation would there be if a respondent says, okay, I think I need to get some help?
I think if the respondent disclose the third-party funding, the arbitration award would be binding, whatever the claimant situation is. However, if there is no disclosure for the third-party funding and there is an economic interest to the final award, I think it's maybe set aside in accordance to the New York Convention, Article 5.
Why?
Because the disclosure it's required, and the claimant hided that he is relying on a third-party funder.
So disclosure is required where?
It is required, even under SIAC, it's required to disclose any interest in the outcome of the arbitration.
Okay, you don't get that in the New York Convention. Where do you get that requirement?
The requirement, it's simple in under SIAC rules. It's like any party, whether a company or a person who has interest in the outcome of the arbitration, then there must be a disclosure.
Correct. So when SIAC says in their notes that a tribunal may take account of the existence of any external funder, what would you imagine would be the pros and cons? When would it be more? When would it be less? What factors are negative and positive here?
Maybe such a relevant to the case and the dispute itself. As if there is any terms in the third-party funding agreement, there's a terms connected to the dispute itself and maybe affect the dispute and the outcome itself.
Well, yes. So you see that this is something obviously a tribunal cannot know in advance. They don't know who has the strong case. And they know at the end that one party probably shouldn't have brought this case because it's not successful. And then maybe they would feel that it is correct that the losing party, which shouldn't have been brought into this case. But in other circumstances, okay, now I'll say an opinion. In other circumstances, a tribunal might say, this was a bona fide dispute. I mean, we understand why each side thought it was right, claimant and defendant. Unfortunately for us arbitrators, we had to make a decision. And the legal arguments were quite close, but we have to make a decision. We can't say this is kind of go away. This is too difficult. We make a decision, and on the basis of that decision, it appears we can take into account maybe the fact that it was very close, and maybe we don't want to punish the losing party. Whereas in another case, you'd say this is a crazy case to bring, and you caused all these costs to be attributed to you caused all the costs of the respondents of defending this case, which shouldn't have brought. You might take a different role. I'm assuming this is what the drafters of this note wanted to get at. Does anybody strike anybody?
I believe we have one comment up here in the front. Is it Sarah? No? Okay. Yeah. So yeah, maybe if I can repeat what you just shared, the last
Sure.
sentence, there could be different scenarios in different cases. In one scenario, the case might be very straightforward. The losing party has obviously had no legitimate reason to actually file a case and cause so much damages and costs for the winning party. But then the other scenario is that no, it's each party has legitimate reasons and a strong case. And therefore, the tribunal might say, okay, this is sort of, it was almost 50-50. So might just allocate costs each to as their own without punishing, the loser.
Even though one of them won big.
Yeah.
But the problem is if one of the parties resorted to a third party funder, couldn't that be an indication that they might have a strong case? Because a third party funder wouldn't accept to fund the case if it didn't have some sort of merit to it. That there is this possibility that they would win on the merits of the case.
That's a fundamental and very good point. But then you get to the point that there are third-party funders and there are other third-party funders. And it is said, I don't know. I mean, no sociological study or economic or econometric study has been made of this. There might be, it is said that there are some adventurous third-party funder. This is usually at the end of the case when one party complains, having lost, and says these people are really bad people. And they like to speculate on third-party funding, and they know that some of these cases they can really win a lot, and therefore we look at that differently, and they should be that should come into the cost accounting at the end when they have brought cases that shouldn't have been brought because the case was very clearly in favor of the respondent.
But in terms of being adventurous, because the decision with regards to the costs of arbitration, the third party fund in itself or the adverse cost would be taken into account in allocating the cost or deciding the costs. But what if a party doesn't care, taking into account that what they are requesting from the other party, like for example, in our case, they're asking for damages, that would exceed whatever costs could be attributed. So they're willing to take all the costs if they're getting 3,300,000, if the cost would be 1 million, they will willing to pay that because they would be getting 2,300,000.
Yeah. Well, I suggest to you, and I'm not saying this is something you have to agree with, and I'm not saying I necessarily agree with it, but there is a possibility that in the universe of this kind of activity, there are situations in which there shouldn't be any criticism of a party which has sought out a third-party funder. And that should not affect anything because it was a legitimate case. So you imagine one where the balance is quite fine. And you really would hate to think that a party which had a perfectly decent case might lose, but a decent case, that they're prevented from bringing it because they don't have. Are you going to punish them at the end, full speed, because they lost at the end? Well, and in other cases, you think, no, it was adventurism and you have a difference. I think that's why you find the difficulties of the case that you'll be facing here in the exercises, that is really difficult to have a hard rule. And unfortunately for the arbitrators, you have to leave it to their discretion. And believe me, they will be criticized for whatever they do at the end.
I have one more comment as well.
If you'll allow me, it's a question not necessarily related to this set of questions. So my question is, if we have a third-party funder that isn't involved with either securing an after-event insurance or providing it, how can we prevent this third-party funder from at any point walking away? That's a concern of a lot of respondents, typical hit-and-run arbitration. How can I, as a claimant, reassure a respondent that the third-party funder I have that didn't help me get adverse costs won't walk away? Therefore, it's not necessary to disclose.
I don't know how you can get to that point before you.
I'll rephrase. So here in our case, we have respondent. Respondent believes that it's really necessary to disclose the entire funding agreement, regardless of any confidentiality clause and so on, because of many different reasons. The influence that the third-party funder has over the claim, as well as the fact that the third-party funder didn't help secure the adverse costs. Therefore, doesn't owe claimant any obligations and can walk away at any point. We want to see the agreement. What are the termination clauses they have? So I, as claimant, how can I defend myself and say, no, actually, the third-party funder won't walk away at any point. You, as respondent, you don't have anything to be afraid of. How can I reassure respondent as claimant in this position?
Very good. And your answer?
My answer, I guess my answer is we've already paid we've already paid our share of the arbitration costs, so there isn't fear of any unpaid cost obligations. And the only reason that this would be a risk if there's a countersuit, which isn't the case now. So respondent, you'll only worry if you try to sue me. So don't sue me, please.
Excellent. I'm not going to comment. Very good. You have put the issue quite well. And it's up for debate.
Yeah, sorry, we have one more as well.
But I have one comment regarding Sarah's question. It's like the claimant already submit the disclose the agreements with the Leadsure insurance company, which provides the adverse cost already. So I don't think it's an issue here because there is already an insurance to prevent something happened after this.
Well, that's a fair point. And what do you make of it? Just so it's clear to everybody.
So actually I'm going to pleading for claimant the procedural. So that's all I got. I don't speak for the respondent. Thank you.
Oh, okay. Anybody
Anyone
else
else?
want to take that bait? Okay, this should be fun.
Yeah.
Behind you?
I'm pleading the merits part, but I believe that this argument is not winning the case because the condition of this assurance of adverse course are unknown for respondents. To who is the person who will get payment, in which amount, it is unknown, and maybe it will not cover all the costs that respondent have to burn in this arbitration.
Understood. Again, I'm not going to comment. I think I get the sense that you're really beginning to focus on the difficulties of this. And when you ask yourself, why does an arbitral institution get involved in telling people what they can do? And then you read the actual words they use, and it's sort of kind of, yes, maybe sometimes and sometimes not, and leaving it to somebody else. It's a difficult, it's an inherently difficult area. And so it's an interesting problem to have for sure. And it really can be very important. As you will have understood, some cases will not be brought because it is known that the respondent is big and has a lot of resources and the claimant cannot match it. And that case will not be brought unless there is some way the claimant can mobilize.
And any final thoughts? Yes.
But the problem is that claimant is getting a bit greedier because they reserved the right to claim additional costs, like they want to get back some of the money to pay their third-party funder. That's the right that claimants reserve. It's not just about bringing in their case and presenting their case, but Not only do they want the 3.3 million as damages, but they also reserved a right to claim additional cost to repay their third-party funder.
You're talking about a particular case.
This case.
I'm not talking about a particular
Okay,
case.
so what happens when the party that has a funder that brought its case with a funder reserves a right or wants to repay its funder through additional cost claims? Is that common? Because it's not part of the merits of the case. It's not a damage claim, but it's a procedural claim.
Excellent question. I'm
Yeah.
not going to go there.
Okay.
It's
Maybe I can ask a question I don't want to answer as well, or I don't even have an answer, but is it really different? So what you explained now, is it really different from a situation where, let's say I am a claimant and I am well off, and I put money from my own pocket into this arbitration or litigation, I would also ask to be repaid for those costs. So why is it different if my brother paid for it and I want to repay my brother or whoever else? I think someone raised their hand.
I think I can answer this question because I have the background like in-house before. So as from the company perspective, I pay all the cost. I should reimburse all the costs regarding this arbitration after I win in this case. That's when you can raise your request during the arbitration and let the tribunal to decide whether it's support or not.
but believe me, there are cases. This actually isn't about outside funders. There are cases where claimants bring good cases. They win, not everything they ask for, but they win. And they have spent absurd amounts. Well, that's an easy case. They're not going to get all of that. That's not going to be a subject of difficulty. And I suppose what you would worry about is that you don't want third-party funding coming in and over-egging the thing and overspending and so forth, and then holding it if they happen to win a case that that the claimant should have won very, very easily and overspent. But that's a situation where the respondent is thinking, where's my insurance?
All right. I think if you have any final remarks or any last questions, I think we can wrap up. Or if
Okay,
we have any final questions, maybe even not necessarily regarding third-party funding per se, since we do have some time. And if you don't mind, we have another 10 minutes.
Sorry, I'm going to raise the question again because I raised this question before during the CAC training, but they didn't answer. They give us a political answer regarding this question. So I think maybe Professor can answer this or not. So my question is—
When did this happen?
1 hour, 2 hours ago. Yeah. I
Okay.
didn't get an answer. So I'm very curious about what's the situation of this. Because I realized, for example, the DIFC changed the act. The act changed the name before. So that makes some troubles because parties enter into agreements before they change the name using the original name of the institution. So after they change the name, they start the arbitration and they're arguing about whether this is the party's intention to choose this institution to be their arbitration center. And it's similar to this case here regarding the 2060 rule and the 2025 rules. Because SIAC changed the rules in 2025, and the parties enter into this contract before 2025, and what's the real intention of the parties? It is, I don't get it. Why the institution like SEAC, they don't publish a rule that before 2025 rules comes into effect, parties agreement, like every arbitration agreements between parties should be referred to 2060 rules rather than 2025 rules, because that's when parties have their agreements, and it's more clear. It's clearer than the time they start arbitration. So what do you think? Like, what should the arbitration center do when they want to change their rules and they change it, but parties cannot make sure what's the real intention?
Just to give you some background on the answer that was given by our colleague from SEAC, they said that they would leave it to the arbitrators and to the students to argue and to give their best defenses or rebuttals, and he reserved his right not to go discuss or disclose.
Yes. Well, let's not forget that institutions, arbitral institutions, and here I include individual arbitral tribunal, they have their own motivations and they have their own risks. So they want to make things clear when it's good for things to be very clear, and they express themselves in quite general terms when they want to have flexibility because they're not sure they've seen everything in the world yet, and things come up that you don't want to be stuck to a position that you've announced. Now, I have some views on this, which I will not tell you today. Maybe later on, because I think it might be relevant to the discussion.
Right. Yes. Again, I mentioned this earlier, but maybe I didn't mention it as clearly. We do have some time, and we can open the floor for questions even beyond third-party funding. So whether it's about the SEAC rules, BCDR rules, arbitration, Bahrain as a seat, anything about law, oral advocacy, the floor is yours, and this opportunity doesn't come every day. So please, and please introduce yourself before you speak, so we all are familiar.
Sorry, my name is Danila. I'm from team of Russian University, Higher School of Economics. And my question is regarding distinction between admissibility and jurisdiction. In commercial arbitration, the main topic in which this distinction is discussed is pre-arbitral steps and multi-tier clauses, but what are other examples of admissibility in commercial arbitration?
What are examples of admissibility?
Yeah, what are examples, and what are examples and how they affect, why it is important to distinguish admissibility and jurisdiction in other examples? Because I ask this question as from all works I read, including your works, I had feelings that this distinction of admissibility and jurisdiction in commercial arbitration makes sense only for multi-tier clauses and pre-arbitral steps, and in other cases is almost not used.
Why should that be so? Why should it only be relevant in multi-tier cases?
That's my I do not say that it should be relevant only in these cases, but unfortunately, I cannot find any other examples of when this distinction is relevant. And what are other examples of?
Well, yes, as in many areas, there are some hypotheses. You imagine an instance where it is very clear which it is. And in other instances, they're sort of merging into each other, and it's very difficult to make the distinction. But as I'm not the first person to make this remark, but the fact that there is something called twilight does not prevent us from distinguishing day and night. That's the best I can do without without our having a long discussion about the various configurations that can occur. But it can be a very tricky question, but in most instances, you know which one it is.
Okay, thank you. Any other questions? You can even think just more personal as you are developing your studies and going through law school. How you see yourself in the future. Maybe if you want any, for example, topics or things that you think of being a law student and how you're going through law school. Maybe I can, yeah, sorry, go ahead. Yeah, of course.
Hi, how are you? Thank you so much for this amazing session. It's been great learning about all of this. I'm actually not part of any team. I'm just a law student here learning. But I do have a question, just for the future when I do decide to get into the Pre-Moot. My question is, how important do you think storytelling is in arbitration advocacy, like instead of like just legal reasoning?
How many?
How important is storytelling in arbitration instead of just legal reasoning? Oh yeah,
If I maybe rephrase, and she was asking how important is storytelling in arbitration pleadings rather than just focusing on the legal jargon. So maybe in a way, like how important in oral advocacy, as part of your oral advocacy skills, is to know how to tell your case in a story sort of way rather than just maybe being too dry.
I'm so happy you're a law student, so I can really, really help you. Legal reasoning is storytelling. And
I believe that sometimes when you say it in a way of like a story, it makes it more understandable. Of course, we would be reasonable and we would use the correct wordings for all of it. But at the same time, do you believe that if we say it in a matter of like a story, it would be more, because I believe some students find it easier to talk in that way rather than,
well,
saying.
Some people have a talent for one thing or another, but the best lawyers know where they are. Sometimes there is a question about the legality of a particular contractual stipulation.
Yeah.
And you can't tell stories about that. I mean, this is just a matter of understanding what the legislature has said and what other cases have held, and you just need to analyze whether that fits as fact in a very orderly fashion. At other times, you really are talking about an assessment of the intentions of the parties as they were doing things which each side thought that they were doing it in accordance of the contract, and an arbitrator then must decide who has the better case, even though in those difficult situations. And that's when the story, what you call the storytelling, comes in, is that you talk about the motivations and the likely motivations of the people who are confronting a particular problem and resolve it in some way. And if you can develop, as a lawyer on behalf of your client, sympathy, by which I mean not I prefer one side to the other, sympathy in the sense of empathy.
Yeah.
I get the position this party was in, and it can persuade me as an arbitrator or as a judge that, all right, this is something which I will hold in favor of them in this regard, because I understand the position they found themselves in, and it seems like their motives were what a third party would look at it and say what I'm going to say.
Interesting. Thank you so much. I appreciate it.
All right. Anyone else have any questions? Yes.
Thank you so much, Professor, for today. I know I asked too many questions, but I'm very curious about you as the commercial court president and also arbitrators worldwide. What's the most difficult decisions that you ever made during the disputes, like to decide which party is in favor in the case?
Which was the most?
Like when you decide which party is the winning party, what's the most difficult time for you to decide? Because like two parties' arguments are similar, and it's very hard for you to decide which party can win the case.
And so I do what?
If I may, if I understood the question correctly, what were some of the most challenging or difficult cases that you've had to decide on where both parties had very strong, equally strong arguments? And how did you overcome that hurdle? What were some of the things that, were deciding for you to go over and shift to this party or the other?
That's
Is that
that's behind your question? If you don't want to decide difficult questions, you should stay out of this area because there are some extreme situations where the position is extraordinarily clear, and there is just no way for one party to accept the inevitable, and it's really obvious, and they have to go through the process, and you have to find out there's a winner, there's a loser, and it's sort of a pity that you even had to have the arbitration because the situation is so clear. Most cases are not remotely like that, and if you have qualms about the fact that both parties had good points, and you sort of want each one to be rewarded for their good points, you're going to have a difficult time acting as an arbitrator. And there might be a range of points, and one party wins more than the other one, and you ultimately have a winner party. But if you're going to be nervous and sort of not sleep at night after you've made a decision, maybe you shouldn't try these kinds of exercises, because when a lot of money is at stake, parties, guess what? They really do get top lawyers who spend a lot of time thinking about every single way you can put the case. And it's very rare that you hear an implausible story on one side and a completely solid story on the other. It's very rare. So you just have to make a decision, and that's what you're paid to do.
All right. Do you have any other questions from the audience? Again, the sky is the limit. You can be as, use your imagination. Maybe I can ask something that might, drag in other questions by other students, if I may. Do you see any trends that are developing currently that students should pay attention to, because there's potential for these trends to grow into very interesting or active or highly used practices? So, for example, maybe 5 or 10 years ago, some people were predicting, okay, AI is going to be the next big thing. And now we're sort of more or less witnessing it. But in terms of, law, international commercial dispute resolution, maybe transnational justice, are there certain fields or pockets or trends that you see that, maybe in 5, 10 years, this might be a big market?
Well, the point is often made, and so doesn't come as news to you, that international arbitration often involves very large amounts, and there are large legal teams that get involved in them, and this has changed arbitration a lot, and in many ways for the worse, in terms of the complexity of the cases and the way that they are presented. So there's been a multiplication of the pages and the numbers of footnotes, with lawyers worrying that they will be criticized if they haven't said everything it could possibly be said, rather than saying, I'm only going to say the things that are going to convince this tribunal. But I'm not sure what they're thinking. So you have to have some confidence that when you make those decisions. And I think the very best lawyers that you see are the ones who have confidence that they have understood the best points they can make, and they don't need 100 precedents in footnotes, which they're telling the arbitrators. I suppose if you have pages that are this much text and then this much single space footnotes, I suppose the person who wrote that thinks that the arbitrators are supposed to read all of that, not only read all of that, but then have a critical analysis to determine whether or not it has any relevance to the case in front of them. And arbitrators, I think, prefer to focus on the case before them and not spend all of their time figuring out whether some other case which has already been decided was correctly decided. So this is a great negative part of arbitration, which we've seen in recent years, and lawyers who like arbitration and want to improve it are trying to think of different ways of preventing it from becoming as expensive as it has become. And I feel that very strongly myself.
There's a question from one of the online teams or students, if we can open it up so I can just give it a read. Being law students, how do we, I guess, make or build a career in international arbitration? So yeah, I think it's quite straightforward. Being law students, how do we, build a career in international arbitration? How do we progress and develop?
It's you call it straightforward. Of course, it is straightforward, but what's the best way to happiness in life? That's a straightforward question. I think I can only say this: if you find contentment in studying these subjects, and if you find international arbitration to be fascinating, I mean, genuinely, you think this is, oh, you start reading it. This is really weird stuff, but okay, people come to outcomes this way, and they can reasoning, and I want to learn this. And you end up feeling that you're studying it with an attraction for it. You actually like studying it. Your friends think you're weird. Good sign.
All right. So I think we will conclude with that on that note. Thank you very much, Professor Jan Paulsen. We can give our esteemed guest a round of applause.
And how does it work? I see everybody again at the...
Yes. So
everybody's here?
Yeah, I mean, even maybe more. Some who are maybe late or missed some flights or some delays, but hopefully we'll have even more. And yes, that's all. Thank you very much. Welcome. It's open